with all of us.
Credit would go to my law clerks. They actually taught me. Whatever little I know.
So we'll say 509, 501. All the learned senior counsel appearing on behalf of the contesting parties, including the Solicitor General, are agreed that the hearing of this referred case be listed on 9 November 2022 at 10:30 a.m. The hearing shall proceed from day to day.
Lighter way, the lot should be sitting in a different form.
Plus the common
Yes, right. The common compilation shall be filed.
Everybody has sufficient time.
The common compilation shall be filed by 1 November 2022. Who is acting as the one-stop window, Mr. Farasat and
Mr. Sadan and Mr. Padmesh Mishra.
Excellent. So that you both continue to do that.
The only thing would be, Manoj, our judgment compilations may be different, which will file in.
Okay. They are making a common compilation of the judgments as well. So you can share your judgments as well with the two learned counsels so that they can prepare a common soft copy compilation for all the judges.
Right.
And for all of
the bookmark?
We bookmark everything.
You have.
Bookmark is here now.
That's right. That's it. And that will really make it very, very easy. And what we can do is if there are additional written submissions, then you can really include them in the written submissions folder so that any addition which happens along the way can be also marked and tracked.
Keep your pleasure.
So now we'll take up 502.
Yes.
Yes.
502.
Because I don't know how you want to proceed with this. But if the matter is going to be heard as quickly as possible, and the matter is going to be decided, there is no need for any of this at this point in time.
Yeah, that's right.
I mean, that's what I feel. Because otherwise, we'll have to argue the whole matter unnecessarily.
It depends
We are
on
considering only IA. We have kept it
I
for IA.
means whether arguing the matter is
virtually arguing. What would you like to do? All right.
May I respond, madam?
Yes.
The same plea was taken on the last date. After hearing the parties, your lordships categorically said that today the two IAs which have been moved and because of which our contention is that the working of the EC is being stonewalled ought to be decided because there is no interim order prohibiting the EC to proceed. And our respectful submission for your lordships' kind consideration was that the main matter and the writ petitions which are pending have no bearing whatsoever on the exercise of jurisdiction by a coordinate constitutional authority under Article 324, which decides the larger issue of a split within a political party. And the nature of inquiry, the nature of powers vested is completely different from what the speaker will decide.
Now, Mr. Paul, if we have to hear the IA is by them seeking a stay.
Yes, yes.
Roughly, what would be the timeline for the conclusion of the hearing?
The only thing I was responding to was because an impression is sought to be given to your lordships is that if this IA is held, then the whole matter might as well be heard, which is completely wrong. Because as far as this IA is concerned, the narrow scope is, and what they're seeking to confuse and deliberately intertwine is the larger issue of the powers of the speaker, which is a completely separate domain from the powers exercised by the EC. And the only basis of their saying so is that if a MLA is ultimately held to be disqualified, what is his locus to go and ask for and determine whether there's a split in a party or not? The disqualification or not of an MLA has no bearing whatsoever of a member of a political party to approach the EC for recognition of who represents the party and the symbol, because as your lordships and repeated judgments have held that a member against whom even disqualification is pending, he can even participate on the floor and vote, even while a trust vote, a floor test, or any business of the house he can vote. So a MLA against whom disqualification is pending can vote
We
and
got the point.
participate, can do both
Mr. Sibal,
things.
would you like to open and give us a
Yes,
broad
sir.
context? So maybe in about 10 or 15 minutes,
Yes,
once
sir.
you open, we'll be able to form a view as to whether we should conclude the IA today, or whether some of the issues which are involved in the IA are so intricately connected with the main reference that we should really then defer the IA for the main reference as you are submitting.
Yes, please.
But let's have some broad framework in terms of the arguments, so that then we'll be able to
In fact,
form a
Manoj,
view.
that's why on the last day, your lodges, after hearing these preliminary
We
submissions,
set down the IA for. You're right.
directed the IA to be listed today. Only on the issue that should the EC be in the meantime,
Should the Election Commission of India be
we are,
prevented?
or is there at all an order? Because according to us, there is no order.
All right, fair enough. Let Mr.
Argue the matter.
Yes.
So what's the prayer in the IA?
Do we see the prayer, Mr.
Where is the IA minutes? Page 55.
5-3. First one,
Convenience
second,
volume 1, page
5-3. Which appeal you are taking?
109. 109. The impeachment application.
Sanjay?
125 is the prayer. The application for that.
This is one submission for your lordship's kind consideration. One of the other issues we had raised was that this prayer is beyond even the writ petition. They have not filed a substantive writ petition. In writ petitions pertaining to the powers of the speaker.
We'll hear you.
I thought I just
consider that.
Very
Yes, Mr. Sibal, are you open?
Your lordship has seen the prayers at page 155.
5-3-3.
533.
There is no difficulties for us at this stage to start learning all this.
No, there's a little issue of the vacuum so much, because the others are all here.
Also needs a cat.
Yeah, let me just
Yes, just give us a broad framework.
just broad framework for what the issue is the following. Kindly don't refer to any paper book. I just explained to you. But this all started on the 20th of June, when in the course of the MLC elections, a seat that should have come to the Shiv Sena, we lost to the other party. That happened on the 20th of June. So on the 21st of June, the meeting was called of all the legislative members of the party. And many of them did not attend. And meantime, many of them had gone to Ahmedabad, and thereafter they went to Guwahati. So obviously, they're obviously not in tune or in alignment with the party itself. So we said that if you do not attend the meeting, there will be consequences. Now, this continued. They did several things between 21st of June. And ultimately they said that, we said, okay, since you have not participated in these proceedings, we remove you. I won't go into the dates. I'm just broadly telling you, Lordship Smith. And ultimately, they were removed from the post that they occupied in the Legislative Assembly itself. They in turn said that you are no longer a leader of the party. We have our own whip now. They all appointed their own whip later. Those all things happened between 21st of June. And when ultimately, on the 29th of, we filed disqualification applications on the 29th of June, which is a very important day. No, hold on. On the 29th of June, which is a very important day. But on the 29th of June, they came here and they wanted to form a separate government in alignment with the BJP. And so, this court, we challenged all that, and this court passed an order on the 29th of June. Kindly note that. Between 21st and 29th of June, whatever happened, I'll tell you later. But 21st of June, it started, and on 29th of June, this court passed an important order saying, having given our thoughtful consideration to the diverse submissions, we do not find any ground to stay the convening of the special session of the Maharashtra Vidhan Sabha on the 30th of June. Tomorrow, that is 11 a.m., with the only agenda of a trust vote. The proceedings of the trust vote to be convened on the 30th of June shall be subject to the final outcome of the instant writ petition, as well as the writ petitions referred to above. So, what happened after the 29th of June in the Assembly, the swearing in of the Chief Minister, the forming of the cabinet, functioning of the government, passing of the trust, everything, this court is subject to the outcome of these petitions. Which means the office of the Chief Minister is under a cloud. Which means what happened in the Assembly is under a cloud. And that will be determined by your lordships when your lordships decide the petition. Then mark the third date, which is the most important date. It is the 19th of July, 2022. On the 19th of July, 2022, Eknath Shinde alone moves the election commissioner. So, it is clear, therefore, that till the 19th of July, he had not moved the election commission. Everything prior to that is subject to the outcome of this petition. He is now submitting.
Mr. Sibal, when Mr. Shinde moves the election commission, in what capacity does he move the
We
election
have
commission?
put him out of the party. He has already given up membership of the party under the 10th schedule because
No,
he's qualified.
when he moves, does he move in his capacity as an elected member of the legislature,
Yes.
or does he move in his capacity as a member of the party?
No, as a member of the legislature, he says that I am the party. This is the whole question, brothers. How will your lordship decide regarding the election matter, brothers, in the context of his moving the election commission and declare himself? You will have to first decide his status. That status will be.
Mr. Sibal, he can move only as a member of the party.
No, brothers.
He has to be.
Please understand, brothers. Sadhically, what your lordship has held is, brothers, that several layers. It has to be counted as to who is the party. And if he is disqualified as a member of the legislature, how will that layer be counted by the election commission? Legislative majority. This can't be done. Election commission can't go into matters, brothers, which are kindly said. The 1968 symbols order, brothers, happened in 1968, where in 1985. He says, herein petitioner so and so, senior leader of the Sena Legislative Party and current Chief Minister of the state of Maharashtra, which is all under cloud by orders of this court on 29th of June. I challenge the very locus of the person, brothers, to move the election commission. The very locus is under challenge.
Which powers of the election commission are being invoked when he moved this application under 19,622? Is it under the symbols order or
Yes, simple.
or 10? It's under the symbols order.
Yes, it's under the symbols order.
So Sadiq Ali 9.
Yes, Sadiq Ali. And Sadiq Ali was at a time when the 10th schedule was not there.
That's right. That's right. That's right.
And this is the very
That is
question
an
that
aspect.
the lordships have heard in the reference. That's the very question referred. Now, if you refer the very question, that means there's a prima facie issue to be decided. Now, my friend is
Mr.
asking.
Sibal, the mere fact that there is a reference which has been made does not stall a constitutional authority from taking recourse to its powers under the law.
But this is also.
Because you're right, that one of the issues which has been framed is the power of the EC to decide upon a split in a party.
Yes.
But that by itself and per se will not really restrain the authority from proceeding ahead if it has authority to decide that under the law.
I don't dispute that fact, but I'm saying prior to that, there are disqualification petitions.
So we got your point. Your point really is that on the 29th of June 2022, when this court passed an order, it made the trust vote was not stayed, but it said this would be subject to the outcome of the petitions.
That's right.
Therefore, according to the office of the CM, the proceedings in the assembly are all under really a cloud, or they are subject to the decision of the petition.
Correct.
And therefore, according to you, the proceedings before the ECI are an offshoot of what has happened before. Therefore, they shouldn't go on pending the disposal of the reference. That really is the sum and substance of your argument.
Broadly, that's what I want to submit to your Lord.
Yes.
Now, can kindly look at it this way. In the meantime, under the 10th schedule, they are members of the original political party. This is very important. 10th schedule does not recognize a split. It used to recognize a split, when para 3 was there. But
Post 2003, para 3 goes.
1st of January 2004, it was removed.
Original political party as legislators or as members.
Yes.
Legislators.
Correct. Therefore, the original
That's under question.
Yes. Now, that means he is a member of the original political party. Now, if he is a member of the original political party, and there is an issue of disqualification that is pending, whether it's pending or not, that's another issue. That again will have to be looked at. Then, if he is disqualified, having voluntarily given up membership of the party under 21A, and having violated the whip under 21B, This all happened prior to 19th of July, when he moved the Election Commission. And your lordship knows, mothers, in Rajendra Rana, your lordships have held, the date of the decision will relate back to the act of disqualification. The day when that act took place. Now kindly have a look at the 10th schedule with me. Your lordship knows, as a matter of law, that when any legislative party and members of the legislative party who are members of the House, the Speaker of the Assembly is conveyed those who are office bearers within the House, namely the whip. Who is the whip? That's conveyed to the Speaker. The whip, the chief whip. They continue to be members of the original political party while that whip is operating. They can't claim themselves to be a faction. But the 10th schedule doesn't recognize that. Election Commission does. The 10th schedule does not. So if you say that you are a separate faction while you are a member of the original political party, according to me, you have given up membership of the party. There's nothing more to be done. Because all of these are admitted documents. This is not evident.
Therefore, Mr. Sibal, the position really is this, that the 10th schedule post 1/1/2004 does not recognize a faction or the 1/3 split which it recognized prior to 1/1/2004 is now no longer recognized by the 10th schedule. On the other hand, you do have the 1968 order, the symbols order, which contemplates that there could be more than one faction of a political party. Now, the 1968 order governs a political party. The ambit of the disqualification provisions of the 10th schedule is the legislative party, the legislature party.
Right.
Because the speaker, in the course of his authority to decide whether there is a disqualification or otherwise, cannot let in evidence saliente to decide as to whether a group of persons are or are not members of the wider political unit called the political party.
No, it does. It does.
That is
to one aid.
Can the speaker, for instance,
Yes.
we note from the written submissions, we are putting this to you because now we have the benefit of seeing the written submissions which have been formulated earlier.
Correct.
They say, for instance, that we have produced 1.5 lakh affidavits of members of the party saying that there is a faction which is represented by them. Now, does the speaker have the power to let in evidence to decide this process which would otherwise fall within the ambit of the EC?
No.
Now, therefore, we have to define, even for the purposes of your interim application, what is the ambit of the jurisdiction of the speaker on the one hand, and what is the ambit on the other hand of the jurisdiction of the election commission.
Correct.
In terms of the symbol order.
Right.
Because the political unit called the political party is a much wider configuration than the legislative unit of that party, which consists of the elected members.
I'm not arguing with us.
Now, does it dispute in regard to the former
Yes.
or the legislative party?
Yes.
affect the authority of the election commission to decide the latter.
Yes.
That is really the heart of the matter that we have.
I will answer that immediately, but let's now see what.
Let's have a look at the 10th schedule. We'll
Yes,
bring
what
some
is the
clarity to
jurisdiction
our
of the
thought
speaker?
process.
Look at 2(1)(a).
2(1)(a), right?
First, let's see the definition. First, look at 1B, legislature parties. The definition of that. 1B. Legislature party in relation to a member of a house belonging to any political party in accordance with the provisions of paragraph 2. Paragraph 4 means, paragraph 3 is omitted if you notice. Means the group consisting of all the members of that house for the time being belonging to that party in accordance with the said provisions.
Member of a house is also.
Member of the house is very important.
That's
And it says, it uses the expression member of a house and member of that house
that's
on two occasions.
that's
So legislature party in relation to a member of a house
correct.
belonging to any political party.
That political.
So
not any.
it distinguishes it says any political party in the first part.
Yes.
So
And then-
the definition distinguishes between a member of a house belonging to any political party
correct.
with the group consisting of all the members of that house for the time being belonging to that political
That's
party.
correct. So, Malad, if it is
And
Shiv
group
Sena,
of that house.
that if it is Shiv Sena, it is Shiv Sena. If it's BJP, it's BJP. Because they have fought the election on a BJP symbol or a Shiv Sena symbol, and therefore they belong to that political party.
So we'll really have to then look at what is the ambit of the disqualification provisions and then contrast it or see if there's an overlap with the
That's right.
1968.
That's the exercise. That's why I said that if ultimately we have to decide all this, we are really going into.
So really the ambit in our eye is short. So according to you, one does spill over onto the other.
Yes.
You can't decide that as the election commission without having to comment on
That's-
the disqualification, which is an issue pending before the Supreme.
Yes, this is the point.
That is the point.
Now, kindly see
Now let's see 2(1)(a.
Yeah, no. First, see
Yeah.
three, Malad. Original political party, not 2(1)(a). 1C. Original political party in relation to a member of a house means the political party to which he belongs for the purposes of 2(1). So he belongs to the Shiv Sena. He is under the discipline of the Shiv Sena, under the control of the Shiv Sena, within the house. He has no other persona. Can't be a faction.
Being a member of the political party,
Yes,
he is a member of the house.
that's good.
So the relationship is with respect to his membership in the house.
With reference to the political party which set him up as a member.
That's the,
That's correct.
but the
So,
schedule,
in fact, Malad, this is the first time in the Constitution that the term political party is used. Nowhere else in the Constitution
first time.
you find that expression. Now,
In fact, the classical books on constitutional jurisprudence in India all mention that the expression political party has not been defined anywhere at all.
luckily we know
It's
something
first
about
time it is in the symbols part, which predates 10th schedule.
Now see Malad's 2(1). Subject to the provisions of 4 and 5. Again, Malad's 3 is missing. A member of a house belonging to any political party. Again, the word any is used. Shall be disqualified for being a member of the house if he has voluntarily given up membership of such political party. Not the house. If you're asked, for example, I belong to one party. I've been elected on the symbol of that party. I go with a leader of another party to the governor and say, meet him and say, please call the House for the purposes of determining who has the majority. Just give you an example. That act alone will visit me with consequences under 2-1. Plus, your lordship must.
Yes, it will go. Look at it from this angle. If there is a disciplinary proceeding against a member of a political party, if disciplinary proceedings against the member of a political party and the political party expels him, what is the bearing of that so far as his presence in the House? In Amar Singh, they said he will sit only as an unattached member.
Yes,
So therefore, whatever happens in the political party will have no bearing on his position so far as the House is concerned. So he continues to sit as an MLA, but as an unattached member.
Yes.
So therefore, where does the convergence of symbols order and 10th schedule?
Well, that will not impact the symbols order at all.
No, I'm saying, where does that will not impact?
Yes.
But political party's decision is not impacting 10th schedule. And his removal from the party.
Removal is not voluntary. This is the problem.
That's right.
Yeah.
But still his presence as a
But
MLA continues.
He will be disassociated from the party. He doesn't have to follow the whip of the party because he's been thrown out. So he's not subject to any discipline of the party. Because lordships will appreciate that when I am thrown out of the party, it's not my voluntary act. I am thrown out by virtue of the fact that the party does not want me for any reason. But the party can proceed for disqualification against me, but they don't do that. So the speaker then says that because you've been thrown out and I've been informed by the whip of the party that you are thrown out, therefore I'll give you a separate seat and I'll call you an unattached member. Then I am not subject to the whip at all. But then 2-1 he will not come.
Ironically, expulsions are welcome because expulsion doesn't disqualify you. You sit separately, you are expelled. So that is welcome rather than to proceed against for disqualification.
The question is how it would, Mr. Simple, the question is how it would, the disqualification would have effect on the symbol order, deciding the dispute with respect to symbol.
No, but I am member of the original political party. I have been elected on that symbol. I continue to be under the discipline of that party, which are otherwise, it has just huge consequences. Any assembly any government can be thrown out. Any government can be thrown out in this fashion. What is the constitution meant? People go to the governor and throw out the government which is duly elected by the House, by the people of the country. Is this how the 10th schedule is to work? I have never heard in the democratic world that an elected government for a period of 5 years through these machinations is toppled. Why? Because we are discussing some academic issue about jurisdiction of the Election Commission. See the heart of the matter. Where is this democracy going? Any government can be thrown out. And then what happens is that you have your own speaker. He will not decide the petition, the disqualification petition, and you merely.
Now, Mr. Sibal, we have looked at the provisions of the 10th schedule. Could we now go to the powers of the EC? We'll so that we have to see the two sets of.
Just allow me.
Yes.
So, therefore, 218 deals with giving up voluntary membership of the party. Yes. And 218 deals if he votes or abstains from voting in such house, contrary to any direction issued by the political party. So, I am the whip. The whip says you have to vote for the speaker, this candidate for the office of the speaker. They vote for a BJP candidate. Now, all this happens after 29th. which is all the subject matter of this court's order. Which he belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party. Person or authority and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So if somebody votes contrary, it can still be condoned by the political party. What it tells you is that the political party is in control. See the expression, condoned by such political party, not by a member of the House or of the people. Well, that's kindly appreciate it this way. Legislative members of a political party function within the overall control of the political party. They are representatives of the people. They are not independent of that party. So the political party will then communicate to the chief whip, condone what he did. I mean, he didn't vote for us, doesn't matter. We don't want to take any action against him. Or he didn't come for voting, doesn't matter. It happens many a times. But there's an umbilical cord link between the member of the legislature and the political party. They're not separate issues. There are issues that your lordships will have to decide, which is what I said. Ultimately, those decisions will have to be taken by your lordships in the overall context. It can't possibly be, assuming your lordships were to, your lordships were to allow the election commission to go on, proceedings to go on. Some decision is taken. Let's assume that. Right? And in the meantime, these proceedings take place and he is disqualified. What's the consequence? These are issues of great moment for our democracy. Can we see, Malas? Explanation. This is also important. Explanation for the purposes of this subparagraph means an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. He can't say that I am